colleague said, I'm going to talk about succession when it comes to testate succession, where someone has written a will. Now, some of you might be wondering, what is succession? Succession is the act of being outlived, or the act of someone else taking over your obligations and rights once you've died or once you're dead. Yeah. Now, there's someone dying when they've not had a will, and then there's someone dying when they've had a will. That is what we call testate succession. Now, I'm not going to go into the nitty-gritties of a will being valid or not. I'm assuming that there's a will and it is valid. Now, in a will, usually the testator, who is the deceased, mentions the person who is going to make that will, enforce that will, if I'm to use, lay language. And that person is called an executor. But there are also incidences where someone writes a will and it is valid, but then they do not appoint anyone. And in that case, there are so many people who can be executors of that will. For example, the spouse, if they have any, or the administrator general. Now, once there's a will and an executor has been appointed, one would require what we call probate. Now, probate is the authority that would be granted by a court with competent jurisdiction to the person named therein as the executor to go ahead and enforce the will or execute the will and manage the estate of the deceased person. Now, this probate can be acquired from any court that has competent jurisdiction. It can be High Court or it can be the Magistrate Court. Now, what would you determine? How would you know where to go? First of all, if you're put in this situation, you need to know the properties under this estate. And it is the monetary value of that property that is going to guide you on where you're going to go. For the Magistrate Court, it's the civil jurisdiction that would apply. For example, if the value of the estate is not above 50 million, but it's like 50 million, you go to the Chief Magistrate. Then if it's above 50 million, you go to the High Court. Now, what would you require before you go ahead to acquire what I defined as probate? First of all, you require the death certificate to prove that and confirm that this person is actually deceased. You need an LC introductory letter from the place where the deceased was living, stating that this person died and the LC chairman person knew this person. Then you'd need your own passport photos and you need a valid national ID to do the same. Then, if you're not a spouse to the deceased, you would also need a letter of no objection from the Administrator General, as my colleague had earlier thrown light about. Then after that, most of the work now is going to be for a lawyer. This is because getting probate is in form of a petition, and that is legalese. So the lawyer would know how to take it on, through a petition with all those documents attached. Then you have to definitely pay filing fees and then file the documents. However, before you do this, there's a requirement of gazetting, or let me say advertising the fact that you're planning to acquire probate in court. You advertise it in a newspaper with wide circulation, and this is meant to reduce cases of fraud, such that in case you're probably holding out to be a relative of the deceased or to be an executor, someone in the public can easily say, I'm objecting to the same. And they do this by lodging a caveat. I'm sure we are well acquainted with caveats in land law. Now, even in succession law and family law, we have a caveat. If you have a reason, or what we usually call grounds, for example, that there's likelihood that the estate will be mismanaged or will go to waste, you can lodge a caveat and say, no, let's say Isabella cannot get those letters. And then the court you'll take it on will court, and then they'll decide the issue. Now, once you have the same, usually it is filed with the registrar of the court according to the value of the estate. Now, once you file with the registrar, you have to go with a copy of that gazette, either through the gazette or through a newspaper with wide circulation. And of course, you have to pay either that media house, or if it is a gazette, you have to pay the fees. Now, once you file them, you're given some time. They will give you a form to fill, and then they will tell you to come back later to identify you, the person. Now, within that period of time, if no one lodges a caveat, as I've explained above, then they will call you to come back to court, and this time around you will come with witnesses. Which witnesses am I referring to? I'm talking about the witnesses to the will. Usually in a will, there are witnesses who attest to it and sign, and during that time they will have said, yes, it is true that they appointed so and so to be the executor of this will, and they will identify you through this registrar. Now, once that is done, you go back, and then they will get these documents and forward them to the judge or the judicial officer in that sense. Now, the judge will approve and then bring back the documents to the registrar. Then the registrar will just sign and put the seal of court. And then you have your probate, and then you can go ahead and administer or take care of the estate. So the effect of the probate is that it will validate or give effect to all those acts that you're going to do on behalf of the deceased. And these rights are not just about the positive things. They are rights and liabilities. For example, if the deceased had debts, if the deceased had obligations, you take everything up in that sense. And you also have some duties to the court that granted you that probate. For example, after some time, as your legal counsel will advise you, you're expected to report to court about how you distributed this estate or how you did what you were supposed to do. That is also a requirement from court. Now, the other question that we saw from our email that people are wondering about is what happens if you have property in Uganda, but you're not Ugandan? Or what happens if you have some property outside Uganda and some in Uganda, and then you want to execute within Uganda? If you have property in Uganda and you're not Ugandan, still under the laws of Uganda, you can be able to obtain probate and go ahead to execute the will. And if you obtain if you obtain probate from outside Uganda, as long as it's a country that's in the Commonwealth system, those same letters can actually apply in Uganda through the process that we call resealing. There's an entire act and rules to do with that your legal counsel will advise you about. And the only court that has jurisdiction to that is the High Court in Kampala. And this is done with the Chief Registrar of High Court. And it's by actually just an ordinary letter. So to respond to one of our viewers, that is how we'll take it on. Yeah. Now, it's also important to note that until at least a week, that is 7 days have passed, after someone has died, you cannot apply or get this probate. Yeah. So once again, I'm Counsel McLean, and with me was please don't forget to like, share, subscribe.
Yeah, and follow us on other social media platforms. And for the person who asked, that is it. And if you need maybe any more information, you can reach out to us on our email on the screen. Our Twitter is open, Instagram, wherever is comfortable for you. So yeah, next time we shall be looking forward to answering more questions in any field of law. Yeah, so don't forget to like and subscribe. Yeah, till next time.
See you next time.
Bye.